Good evening, everybody. Please, I would like to confirm if you can all hear me.
Go on, we can hear you.
Okay, good evening once again. My name is Mariam Suleiman Richifa, and I will be your moderator for today's session, which is titled Unleashing the Rudiments of Corporate Litigation. And this topic will be taken by Mr. Abraman Nasir Salis, and he is presently with us on the call right now. You're very much welcome, sir. So, I would like to talk about business law bootcamp before I read out the presenter's profile. And I think when we say bootcamp, we know that it's a very common word, yeah. And one of the purpose of bootcamp is for personal development and self-improvement. So, Business Law Bootcamp is a program that provides students with a practical understanding of various areas of business law. And this particular one was actually put together by, should I say, a group of law students? Yeah. So, this bootcamp is aimed at empowering aspiring commercial lawyers with tools, knowledge, and discipline necessary to achieve professional excellence. And I will now move forward to read our presenter's profile. Mr. Abraman Nasir Salis is an associate in Nigeria's top-tier law firm, G. Elias. He represents, assists, and advises local and international clients in a wide range of transactions and projects, including bonds and commercial paper issuance, foreign investment advisory, asset acquisitions, construction, dispute resolution, amongst others. Its practice area covers capital market transactions, disputes, electric power, oil and gas, projects, and new economy. Mr. Abdurrahman Nasir Salis has a track record of academic excellence. He bags Justice Muhammad Nasir Bello Award as the best graduating student of the Faculty of Law, Bayero University, Kano, and has his BL with 4 distinctions and a B plus from the Nigerian Law School, Lagos campus. So at this juncture, I would like to welcome Mr. Abdurrahman Nasir Salis to start with his presentation. You're very much welcome, sir.
Thank you very much, Mariam. And thank you, everyone, for having your time to think on organizing this program. I believe from the establishing the camp, it shows your readiness to learn, and it shows how dedicated and keen you are to self-optimize yourself, which is actually a good one. With this kind of events, engagements you're having with people who are already ahead of you in probably the business law aspect that you would like to develop a career, I believe you get more insight, and from there you understand what you really need to achieve in the future, in the legal profession, and in your life generally. Well, thank you very much once again. So, like the moderator Miriam has spoken, or she has said, the title of the topic, the title we are going to discuss today is Unleashing the Rudiments of Corporate Litigation. So, I'm not going to take much of your time actually. I'm a little under the weather. So, we are just going to talk about the key points, the rudiments, like you said, things that are that are the essential ones, and the others I believe will just flow naturally, and they are not so essential. So when you talk about corporate litigation is a compound word. I believe we have English guys here who can decode everything in English. I mean, so compound words compound words in English is, or compound noun in English is a noun that is composed of more than a word. Like if you said corporate, it could be a noun, right? Which is a single word. But by attaching it with another word, which is litigation, it becomes a compound noun. So corporate litigation, in a simple term to understand it, we have to like define the word corporate and to define the word litigation. As corporate is, in a simple term, is something that deals with, or an aspect or area of practice that deals with corporation. What we mean by corporation here is company, an aspect of company from its formation to its death. So like just like an ordinary human being that you know, like you and I, we are born, we grow up, we die. So that's the life of company as well. So in the eyes of law, company is just like any other human being. Company is a legal entity in the eyes of law. It can buy, it can sell, it can sue, it can be sued. It can do a lot of things that a human being can do. So in the eyes of law, corporate or company or corporation is just an entity that exists like any other human being. It has legal personality. So this is in essence what corporate means, a practice that deals with this, with companies. And when you talk about litigation in a simple term is a process of taking a dispute before a court of law for resolution. In a simple term, when you take your dispute, any kind of dispute that you have, when you take it to a court for interpretation or for resolution, for whatever reason, you take it to the court, that thing becomes litigation. So if you merge the two words together, corporate litigation, in a simple term, it means company litigation or litigation that deals with company activities. Any litigation that deals with activities of company, you can call it corporate litigation. So I think at this point, it's quite important to basically make a distinction between corporate and commercial. Sometimes it's a little bit confusing to a lot of people, and in many times people use them interchangeably. But in a simple term, sometimes corporate world could intervene or could intertwine with a commercial world. So, but in a simple term, I will try to give you examples rather than definitions for you to appreciate the differences between the two. So, when you're talking about corporate, we are talking about, like I said, companies, right? We're talking about incorporation of companies, that the formation of companies, like giving birth to the companies, and the restructuring, like changing the mode of the company. Initially the company, for instance, it was a public company. You are now changing it to a private company. It was an LTD, and now you're changing it to PLC. These are part of the restructuring that we have. Or raising capital of the company. Like for a company to work, you need capital. It's just like any other business. So for that company to work effectively, you need capital. For that company to go concern, to be a going concern, you need capital. And also like mergers, where two companies will come and form and merge together and join themselves together in order to be one. Or demergers, there are demergers. Demerger is the opposite of merger, right? You have like two companies or three companies that formed into a one company, or that transformed into a single entity, a single company, that want, and now they want to like separate, they want to divide themselves into three. This is demerger. Or acquisition, where one company is acquiring, or where a company will acquire another company. And there are also issues of corporate governance. Like when we're talking about corporate governance, we're talking about issues surrounding the role or the duties of directors of a company that they owe to their shareholders, to the shareholders of that company. Because in a corporate law world, in under corporate law, directors are just like employees of shareholders. So whatever they are doing, they're employees of the company, but they are functioning for the shareholders. So whatever they do, they have to protect the interest of the shareholders of that company. And also issues of like shareholders, right? You know, as a shareholder, you have rights in that company. If even if you're a minority shareholder, if we have like 10 shareholders in a company, we have like 1 million share capital or 20 million share capital, and we have one person that is holding 1 million, and the others are just holding like 5 million. So that person holding 1 million share in that company is just like a minority shareholder. So his rights, duties, obligations of that minority shareholder and of the other shareholders, majority shareholders, these are also part of the corporate practice that we're talking about. And also dissolution or liquidation of company. Dissolution is just like saying death of the company, or liquidation. We are liquidating a company, we are dissolving a company. It's just like we are saying the company is dying, or we are killing that company. We are going to put it in its grave. So you know there are a lot of issues that will arise. The assets of the company, what, how are we going to do with those assets? Like the company has properties, has landed properties, has cars, houses, and cash in bank, and cash in the office. What are we going to do with those cash if we are now dissolving the company? So these are also part of the issues that form the what do you call it, the corporate practice. And also there are issues of liabilities, right? When you are dissolving a company, you have liabilities for that company. Probably someone owes that company a lot of money, or the company owes someone a lot of money, or another company, something like that, or bank and stuff like that. So you also find a way of how to deal with all those liabilities. So these are also part of the corporate practice that we are talking about. And these are also part of the corporate practice that we're talking about. So I believe with this few examples, you will understand that when you're talking about corporate practice, we're just talking about life of a company from beginning to an end. anything that happens for a company from its formation to its dissolution, all those things are, I believe, corporate. Let me give you an example. I think of that was 2019 or 2020. I can't remember exactly. MTN has issued some shares, like allowed public, invited public to come and subscribe to its shares. So I believe that is also part of the issues that a corporate practice that you will come across in corporate practice. Like a company will invite people, come and buy my shares. So if you are coming to buy those shares, there are a lot of principles of law, there are a lot of principles governing those stuff. So they are also corporate practice. And when you talk about commercial, they are also dealing with company, but the only difference is that they are not like in the life of the company, and they are not after the death of the company, but always company is involved in commercial transaction, or businesses are involved in commercial transactions. Let me give you some examples, like contract. If you are entering into a contract, a company is entering into a contract for the supply of some goods to that company worth billions of naira, that is commercial. If consumer laws, right? You know, consumer, as a consumer, I'm buying a product from a company, I'm the consumer of that company. So if the product I'm buying, the transaction we are doing, it's commercial. And also there are issues like employment and labor law. Like employment, a company will employ people, or a company will employ contractors to come and do work for that company. So all these are commercial. And there are also issues around international transactions and trade, like a company, Dangote now, Dangote, that establishes a new company, right? Establishes a new refinery. Um, Dangote establishes a new refinery of recent, Dangote company. So that company will be purchasing crude oil from, I believe, of last week that I read in news that Dangote will be buying crude oil from America, United States of America, and some other countries in the world. So this is like international trade. This is international transaction. So this is commercial. So any dispute that has to do with these examples we give in respect of commercial, you can call it commercial litigation. And any dispute that deals with life of the company, that deals with the company from its formation to the end of the company, to the death of the company, for lack of a better word, is corporate litigation. I believe corporate litigation is clear for now. So I believe the goal of corporate litigation in to lawyers is basically to avoid litigation. The whole essence of corporate litigation is to avoid litigation, not to do litigation. If you find what do you call it, a corporate litigation lawyer worth his salt, he will always tell you, he will always advise you to avoid litigation. Corporate litigators are kind of lawyers that do not like litigation. Not like they don't do litigation, but they don't like litigation. They will always tell you or find ways to tell you how to avoid litigation. So part of the ways to avoid litigation is always to get a good lawyer, to get a good corporate lawyer that knows the risk of the business you are going into, that knows the risk involved, that knows how to manage the risk and advise you on how to go about it, even before the happening of the dispute. So that's why it's good to get a good lawyer that knows how to draft documents, because everything is on document. For instance, I gave you an example under corporate that will have shareholders in that company. So basically, you come to enter shareholders agreement for that company. So if you have a good lawyer, that good lawyer will tell you what to insert, what to put, how to coach, how to arrange, how to organize that shareholders agreement in order to avoid litigation. So this is one of the fundamental things to look out for all the times. So let me also give you another instance or examples of corporate litigation that you come across in the world. the examples we have given already. So, like you see, number one, you can come across dispute between company and shareholders. Sometimes the company will be having dispute between itself as a company and the shareholders of that company. Probably because, like under the law, under CAMA, for instance, Companies and Allied Matters Act, for a company to have a meeting, a shareholders meeting, all shareholders must be invited. So if as a shareholder I'm not invited for a meeting, that is a dispute. I may raise it. I can say I was not invited when the decision was taken. So, and I can take that issue to court, right? That is a corporate litigation. We can also have issues like around surrounding um, power decision making within the company. Who has the power to do this? Who has the power to do that? Who has the power to appoint a director? Who has the power to remove a director? So all these are issues that may likely arise in the life of the company. And we could also have disputes relating to procedures for mergers, for dissolution, for acquisitions. And we can also have issues regarding breach of contract. These are also corporate issues. And we can also have issues related to appointment and removal of directors, appointment and removal of secretaries of the company. So all these are examples of corporate litigation. So, like I said, the goal of corporate litigation is always to what do you call it, to avoid litigation. So the ways to avoid litigation, like I said, is to find a good lawyer that knows his audience, and secondly is also to choose the right legal structure for your business, to know the kind of business you are doing, and to choose the appropriate legal structure to use for your business. Sometimes you will see some companies doing a lot of having a lot of subsidiaries and having a holding company. The holding company may not necessarily do business, but it's just overseeing the other companies that are doing business. So it depends. You have to look at the structure that you need for your business, depending on how big your business is, depending on how big your capital for that business is. All this will determine the nature of the structure that you're going to adopt. So it's always good to get a good lawyer, a good corporate lawyer that will advise you on that. And also negotiation and signing of leases, contracts, and other agreements. All these are ways to avoid litigation. Like if you have a good lawyer, he will know how to negotiate your agreement and what not to do. Let me give you an example. It happens in a real life story. A woman in Nigeria, she is a Nigerian, and she got some people that wanted to come to Nigeria and invest in her company. She has a company. For the sake of confidentiality, I will not tell you the kind of business she's doing, but she has a company. She invited some foreigners to come and invest a huge amount of money in her business, worth billions of dollars, stuff like that. So, as part of the agreement they have is that she is going to pay off some money to them. They just like lended the money to her, and she's going to pay off within a certain period of time. And if she did not pay the money within the specified period, her shares in that company will be diluted. I mean, they will take over her shares. So that woman, without getting a good lawyer that will advise her accordingly, she entered into the contract, and the company was going perfectly. But at the end of the day, she failed to make payment to the people that invested their money in that company. So they kicked her out of the company. She was the founder of that company, but because she entered into an agreement with those foreign investors, how to on the consequences that may follow if she fails to settle them, she ended up getting herself out of that company. So that's why it's always good to get good lawyers that will tell you what to do, that will tell you what not to do. And also, to avoid litigation in corporate litigation or in corporate practice, you need to have a fair hiring and termination system in your company. As a company is it's damaging to the reputation of company when your employees are taking that company to court. It's damaging to the reputation of the company when a company has a lot of cases in courts. So it's damaging. So it's always good to maintain a good and fair standard or procedures of hiring employees and procedures of firing your employees. You cannot just wake up in a day and say, I hire you, and tomorrow you can say, I fire you. So you need to comply with the international standard, best international practices of employment. And also, a company to avoid litigation, that company needs to comply with new like accounting principles, corporate governance regulations, and also company needs to structure investor financing. If you have an investor that would like to come and invest in your company, you need to get a good structure for that in order to avoid litigation. But once the dispute happens, litigation will likely come either from the part of the company or from the part of the other party involved, probably an individual or another company. So now it's important to, since we have talked about dispute that may likely arise, and when it arises, we know that we will go for litigation, right? So we are going to talk about issues to look at in corporate practice before going to litigation. Remember, your key thing to note in corporate practice, the most important thing to take care of, to always put at the back of your mind as a lawyer in corporate world, is that business of your client matters. Business of that company is the paramount thing to look at. There is no point in you taking a matter to court while at the end of the day the business of their client, the business of a client, the business of your company will be crippled. So it's always important to put at the back of your mind to look at the litigation, that we are going for litigation. But even if we are going to win in this litigation, would that have adverse effect against our business? If it's going to have an adverse effect against our business, against the company's business, then it's not worth pursuing. So that's why I told you corporate lawyers are the ones that do not like going to court, not because they don't know how to do it, but because they prioritize business more than the court, or let me say, more than the litigation. Or like a pure litigation lawyer who doesn't know corporate world, who doesn't know corporate practice, what matters to him is let's go to court. He doesn't care about your business. He doesn't care about the fate of that business. The business is going to cripple. The business is going to is going concerned, but because of this litigation, this business is going to end. This and that. He doesn't care. So as a corporate lawyer, you have to think like a businessman. That's why sometimes you hear them telling you that corporate lawyers are just businessmen. So you have to think like a businessman as a corporate lawyer, thinking that this is my business. Just if your client comes to you with an issue with his company, just look at that company as your business. Your ultimate goal as a corporate lawyer is to save that business. So now the issues to look at before going to litigation, there are a lot of them, thousands of them, a lot of them. Like now I told you, look at the business first, right? So there are issues that you need to look at. Number one, we can say the cost of litigation itself. How much are you going to spend for this litigation? Let's say the dispute is over $1 million, for instance. And if we are going for litigation, we are going to spend $150 million. I mean, the cost of litigation is more than the amount you're going to spend. So if we are business oriented, I believe we'll just avoid the litigation and save our money, right? So you have to look at the cost of litigation. And also, it's always important to look at limitation period for commencement of an action. There are limitation periods, limitation laws in various states, and we have limitation act at the federal level, right? This limitation act will tell you that if so thing happen, if you did not take it to court for a so period of time, you are stopped or you are barred from taking it to court. You cannot take it to court again. So like in issues of simple contract, if there is a breach of contract and you do not take it to court till after 6 years, you cannot take it to court again. You are stopped from taking it. You are barred from taking it to court again. You cannot take it. So you have to look at the time the dispute occurs and the time you are taking it to court. So once it's more than the period stipulated by the law, depending on the nature of the dispute, once it's more than the period prescribed by the law, just advise your client not to pursue it. It's not worth pursuing, because even if you take it to court, the other lawyers will simply raise an objection that the court has no objection because the matter is stated bad. So you cannot take it to court. And also, it's important to always look at the court that has jurisdiction, competency. I mean, the court that is competent, that has the competent jurisdiction to take the matter to that court. So, for instance, there are a lot of corporate disputes that are that it's only Federal High Court that is vested with. In most cases, let me even say it. In most cases, it's usually Federal High Court that has jurisdiction over corporate disputes. In most cases, there are exceptions. Because if you read Section 251 of the Constitution, you will see that operation of Companies and Allied Matters Act, which is like the prime law governing corporate practice in Nigeria, the operation of that act is any dispute that arises because of the operation of that act should be taken to Federal High Court. It's only Federal High Court that has exclusive jurisdiction over those cases. So you cannot take it to Sharia court, for instance. You cannot take it to Magistrate Court. You cannot take it to even State High Court. You have to take it to Federal High Court. So like issues around minority shareholders. As a minority shareholder, you have complaint against your company, you have complaint against the majority shareholders. You can only take that to Federal High Court. You cannot take it to State High Court. Or issues surrounding copyright, right? All these issues of copyright. I believe there is even a recent case going on between for those living in Kano, you know the issue of Pop Cola and Coca-Cola, right? Coca-Cola and Pop Cola about this patent and stuff like that. They took the matter to Federal High Court because it's Federal High Court that has jurisdiction. You cannot take that matter to State High Court. So in anything you are doing as a lawyer, as a corporate litigation lawyer, you have to look at the jurisdiction of the court. I'm taking this matter, which court has jurisdiction? But there are instances where even if a company is involved, it's not the Federal High Court that has jurisdiction. For instance, let me give you an example. When you have employees in your company and you terminate their employment, it's not Federal High Court that has jurisdiction. The court that has exclusive jurisdiction in respect of that is National Industrial Court. So you cannot take it to Federal High Court this time around. So you have jurisdiction is essential. And jurisdiction, like they say, is just like a life blood, like the bloodline. I mean, it's just the blood of the company. So without the blood, a man cannot function. You and I cannot be alive without blood. That's why once we got injured and we are bleeding, they will try to stop the bleeding because once we bleed it out, everything will just die, right? So jurisdiction is just like the blood of every suit that you are instituting to court. Without jurisdiction, no matter how perfect decision is, without jurisdiction, that decision is going to be a nullity. So another issue to look at is issues around pre-action notices and letters of demand where applicable. I mean, by this, what I'm saying is sometimes you need to look at issues. There are issues of pre-action notice. By pre-action notice, we mean sometimes you find mostly pre-action notice is statutory. For instance, if you want to sue, let's say you want to sue Ministry of Finance, you find out that in the act establishing the Ministry of Finance or in the law establishing the Ministry of Finance in your state, you find out that the law states that before you can take Ministry of Finance to court, you have to give a pre-action notice. It's just like a letter informing the ministry that I am suing the ministry because of so reasons, and I'm giving you 30 days. If you fail to resolve the issue within 30 days, I'm taking you to court. And the following are the kind of the reliefs I'm going to ask in court. I will ask court for declaration. I will ask court for an order to compel you to do this, to direct you to do that, and whatnot. So pre-action notice is always important. If you fail to give pre-action notice when pre-action notice is required, so that suit will not stand. And also, as a corporate lawyer, you have to also think of the name of the party you are taking to court or the name of the company you are taking to court. Because Corporate Affairs Commission under the Companies and Allied Matters Act is the institution responsible for registering and incorporating companies in Nigeria. So each company has a unique name. By law, no two companies are allowed to have two exact names. You cannot register. You cannot register Mariam Limited and register Mariam Limited again. You cannot do that. So Corporate Affairs Commission has a database where that database has everything, has all the names of the companies. Once you put in your reservation of name application, you want to reserve a name to register a company, they will tell you that this name has already been taken. Just like your normal social media handles, that if you're trying to put to choose a username, they will tell you that this username is not available or this username has already been taken, right? So it's always good to know the company, the name of the company you are suing, as it is on the certificate of incorporation, as it is on the certificate of registration. So I remember we had a case one time where someone sued MTN Nigeria, and the person sued MTN Limited, sued the company as MTN PLC. MTN PLC. And MTN was our client in that case. So we raised an objection in the court that we don't know anything like MTN PLC in Nigeria. Nothing like MTN PLC. So the suit was struck out because of that. The registered name is MTN Nigeria PLC. So because he said MTN PLC, the suit was struck out. So it's always important to look at the name, to know the name as it is exactly on the Corporate Affairs Commission database, as it is exactly on the on the Corporate Affairs Commission certificate of incorporation or certificate of registration, before you can take out a suit or before you can take out a writ against a company. Otherwise, you will ended up spending your money for filing the suit, and at the end of the day, you end up wasting your time as well. And also, you have to look at the remedies available to you as a corporate lawyer. What remedies are available to me? I mean, if you are employing, if you are into, if to say you have, for instance, a client that was an employee of a company that was sacked by a company, and you are taking the company to court, and you are now asking the court to reinstate that employee, to order the reinstatement of that employee cannot get the relief, because the court will not impose an employee on an employer. I don't know whether I'm making sense. What I'm saying is that if I am your employer and I sack you, court cannot impose you on me. Court cannot compel me to reinstate you. Court cannot compel me to work with you. It's my right to hire you. It's my right to work with you. It's my right to say, I don't want to work with you. So the only instance where court can compel an employer to work with an employee is for employment that has statutory flavor. Like, for instance, you are employed under the Federal Revenue Services. You are an employee with statutory flavor, not just a private employee. So in that event, the court can compel, Federal, sorry, what did I give? FIRS, Federal Revenue Services, to work with you, because it's not an individual business. It's not a one-man business. It's a statutory company. It's a statutory entity established by the law. So another thing to look at is whether we have other forms of alternative means to resolve the dispute even before going to litigation. It's not always advisable as a corporate lawyer to always think of going for litigation first, or to always advise your company or your client to go to court for litigation. You have to first sit down, think, and see whether you have other ways to resolve the dispute before going to court. So that's why sometimes you see in most cases, even in the agreements we draft for companies, for clients, we insert clauses for settlement, for negotiation, for mediation, for adjudication, for other means of alternative dispute resolution to resolve the dispute before going to court. So one of the common things now that people do or companies do in when it comes to dispute in most cases, companies prefer to go to arbitration, which is an offshoot of litigation, than to just go for litigation. Litigation is within the ordinary or the traditional courtrooms we have. So arbitration is more flexible. Arbitration is more flexible, and arbitration is more speedy. You do it expeditiously without wasting much of your time, or like litigation where it would take 20 years doing litigation. You will see cases that have lasted, I mean, for 15, 20 years in Nigeria and more. So, but arbitration, it's fast. Sometimes it's even the parties that will put in the number of days they want the arbitration to be done. They will tell you that we are going to appoint an arbitrator in so days, and that arbitrator is going to determine the suit in so days. So these are part of the issues that you have to look at. Although in arbitration you spend more money, in most cases you spend more money because you're going to pay the arbitrators. Or like in the litigation, the judge, you're not going to pay the judge. It's the government that is paying the judge. But even in arbitration, one feature that is common in arbitration, which is also common in litigation, is that the decision is binding. The award, the decision that you get after arbitration is called award. That award is binding. You can go to court and enforce the award. Or like in mediation is just you have a third party neutral that will sit and try to see how he can settle you. Reconciliation, you just discuss on how to reconcile the issue. So all these are alternatives to the litigation aspect that as a corporate lawyer, the corporate world is evolving towards, or is tilting towards, resolving disputes without litigation. So corporate lawyers do not like litigation. Like I said, the goal is always to avoid litigation. Corporate lawyers always prefer to go for alternative means, alternative dispute resolution mechanisms, the ones I just told you, which are mediation, adjudication, arbitration, reconciliation, negotiation, in order to resolve the dispute. I think with this, you guys will have like a fair idea of what corporate litigation is all about. Thank you.
Thank you very much, sir. This was a very wonderful lecture. It was very inciting and educating, sir. Thank you very much. It's nice having you here. So, in absence of Mariam, I will continue the moderation of our meeting for today. So, the next thing on the agenda is Q&A session. If there is anyone who need any clarification, who want to ask any question, you should kindly signify and go on, please. Anyone with question from what the lecturer just finished, please? If there is any question, okay, you can kindly go on, Adera.
Good evening, everyone. Good evening.
Good evening.
Hello, can you hear me?
Yes, we can hear
Yeah,
you. Go
you
on.
made mention of yeah, okay, sir. So you made mention of you suing the company by knowing the name of the company as it is on the CAC certificate of incorporation. So does it actually suffice suing the company as you see their name written boldly on their, maybe on their billboard, on their signboard, or whatever? Like, is it actually important to take into cognizance the actual name they used to register that company on the CAC certificate of incorporation, or mere seeing the company's name on the billboard or signboard suffices? That's my question, sir.
Okay, thank you, Adera. I think it's very important to always, like I emphasize in during the course of the presentation, it's always important to know the exact name of the company you are suing. Not just the company. Let me give you an example. If your name is Adera Muhammad A, or Adera A Muhammad, for instance, and I sued Adera Abdullahi Muhammad, these are two different persons. Adera A Muhammad is different from Adera Abdullahi Muhammad, because that A in your name could stand for Ahmad, could stand for Abu Bakr, could stand for Abdurrahman, could stand for many things. So if you are suing a company the way you see it on their billboard or whatever, that may likely put you into trouble of instituting that action, or that may likely put you in the trouble of applying to court to change the name or to amend the name, depending on the nature of the mistake you have committed. There are mistakes that are just called nomenclatures. I mean, misnomers. If it is just a mere misnomer, the court may allow you to amend it. Like, I want to sue Adera A Muhammad, then I sue Adera A Mohammed. Muhammad and Mohammed are two different things, are two different names, but they are just misnomers. So the court may allow you to just amend it. But if I'm suing Adera Muhammad PLC, and I ended up suing Adera PLC, this is not a misnomer. Adera PLC is an entirely different entity from Adera Mohammed PLC. So it's always important to look out for how the name is registered. And there are many ways to find out. Like, you can just go to the website of what do you call it, Corporate Affairs Commission. Check out for the name. You will see it on Google. You can just search, get the RC number of the company, search it, put it on the portal. It will show you the exact name. It will show you the date of the registration of that name. It show you the shareholders of the company. It show you the directors of the company, secretaries of the company, everything about the company you would like to know. You can get it online on their portal with the token. It's just 5,000 or 10,000 that you pay, and you get everything. So it's always important to take cognizance of that, not to, and don't rely on what you see on the billboard or signboard or whatever. Thank you.
Yeah, thank you very much. I really appreciate it.
Thank you very much, sir. This further tells us the significance of knowing the exact name of the company you are suing. Thank you very much, sir. Please, who has any question again? You should signify and then go on, please. If you have any question, kindly signify. Hey, Salabaran, go on.
Yes, sir. Thank you very much, sir. My question is, regarding the service of reaction notice. So I stated earlier that for a company to be served a pre-action notice, yeah, it has to enjoy what we call statutory flavor. That is, a particular statute or a particular law has to provide that that company has to be served with a pre-action notice before you take that company to the court. Now, so what if the company is a federal government-owned company and then there is no any law or any statute regarding that or governing that particular company that states that you should serve it with a pre-action notice? And we all know that the Labor Act or the Labor Act is the principal law that governs any relationship between workers, their welfare, employer-employee relationship and all that stuff. So I don't know, sir. In this particular circumstance, are you obliged to? Sorry, are you mandated to serve a pre-action notice before you take that particular company that is owned by the federal government to court?
Thank you, Isa. This is a good question. Um, let me make it more clear, like, to the others. Isa is asking, we have companies that are owned by federal government of Nigeria. For instance, NNPC Limited, right? NNPC Limited. NNPC Limited Nigerian National Petroleum Company Limited is a company that is fully owned by Nigeria. I mean, the shareholders of the company are MOFI, Ministry of Finance Incorporated, and which other ministry? Is it Ministry of, I can't remember. So they are just like fully owned by federal government of Nigeria. So the question is, you remember we talk about pre-action notice? Hello, can you hear me? Oh,
Yes, I can hear you.
okay, thank you. The question is whether it's mandatory to also serve the company with the pre-action notice. Remember what I told you in the beginning. For you to serve a pre-action notice on an intending defendant, on the company or entity you intend to sue, it's usually the law that will tell you you have to serve a pre-action notice. If the law did not ask you to serve, then it's not mandatory. But let me tell you, it's always a good practice. It's always advisable, except in cases of emergency, to always serve letter of demand or demand letter or pre-action notice to your adverse party, to the party that you are intending to sue, to tell him that I'm taking you to court, put him on notice. Because at the end of the day, by putting him on notice that you're taking him to court, you may come to settle the dispute without going to court. So you save your time, you save your energy, you save your money. And let me tell you a story. Somebody is indebted to another person. Let's say you owe me. Let's say you owe me. What do you call it? Let's say you owe me 100 million naira, right? You owe me 100 million naira, and I'm intending to sue you for that money. So I put it in a letter of demand that, Isa, you owe me 200 million naira. It's $100 million that you owe naira that you owe me, but now I'm telling you it's 200 million naira. So it happens. Something like this happened in reality. The person is owing what do you call it, 100 million naira, and the other guy wrote to him that he is owing 200 million naira. The person quickly wrote to him that it's 100 million naira that I know, not 200. So he take that to court as an admission that he admitted. No need for me to start proving. He has already admitted that he owes me money, right? So the court will just give you judgment that go and pay his money. No need to start calling witnesses, no need to start putting in documents to the court. So it helps a lot. Sometimes you win your case by sending letters to your opponent. I think I answered your question, right? Thank you.
Thank you very much, sir. The question was well answered. I also gained more insight on this particular question he asked. Thank you very much, sir. Please, is there anyone with any further question? If you have any question or you need any clarification from the lecture the facilitator delivered, kindly indicate and ask your question, please. You will have this opportunity to have to ask your questions now.
Yes,
And you know
I
they
have
say
a
at the
question.
end of presentation or at the end of lesson or whatever, if questions are asked, if questions are not asked, it's either you are fully understood or you are not understood at all. I don't know whether I'm understood or not.
You
I have a
understood,
question.
sir. All right, go on and ask your question.
Okay, thank you very much, sir, for the wonderful session. Okay, my question is regarding those alternative dispute resolution clauses that you said. So without imputing those clauses, can the company decide to go for the arbitration mediation, or the court will automatically assume jurisdiction in such cases? Hello, do you get me?
Okay, thank you. Yeah. I sorry, what's your name?
So my name is Stephen Amos.
Okay, thank you, Stephen. Yeah, it's a good question, Stephen. So, like I said, it's always advisable to get a good lawyer, a good corporate lawyer. I don't think in this era a corporate lawyer will draft a document without giving you an option to do an alternate dispute resolution. So one key thing to understand here is that alternative dispute resolution mechanisms are not mandatory. They are just for parties to explore when they need to, when they agree on it. I cannot compel you to go for arbitration while it's not in our contractual document, while it's not part of our agreement. And you cannot compel me to go for arbitration as well. But I can take you to court. I mean, court is compulsory in nature. Going to court is compulsory in nature. But going for arbitration or for mediation, I may say, I don't want settlement. I don't want us to settle. I don't want us to explore arbitration. I don't want us to explore mediation. Whatever mechanism you can think of, I don't want us to follow it. Let us go to court. And if you are served with the processes for arbitration because it's not in your agreement, you can say, no, I will not go for it. Right? And there is nothing they can do. But if you are served with court processes telling you to come to the court and you said, I will not go, the court can go ahead and give judgment without you, and the judgment will bind you. So that's why we have default judgment. Even if you are not in court, you have been served with the court processes, but you refuse to go, the court can go ahead and enter judgment against you as a default judgment. And if it is something that the court will need your presence, the court can compel you to come. The court can ask sheriffs, the court can ask police to compel to arrest you and compel you to come to the court. But nobody can do that for you in mediation or arbitration. So arbitration is optional, right? But going to court is compelling in nature. Thank you, Stephen, for the question.
Thank you very much, sir. I appreciate it.
I can see someone raising his hand. I think it's Aminu. Is it a question or what?
Yes, it's a question. Thank you so much, sir, for the wonderful presentation. Actually, I want to ask a question, though the question is not within the ambit of what you discuss now, but let me just ask the question. If at least it's somehow linked with this, then maybe I'll be obliged with an answer. It's a company. Let's say a company make a production, like produce let's say garment, let's say dresses. So after they produce those dresses, I am a tailor. Then I bought those dresses from the market. But because of the nature of how they sew the dresses, it's not like people around my areas are not like appreciating those materials because of the way it was sewed. So I took those materials after buying them from the market. I then change the design, use the material, but change the design into the shapes which the people of my area will like appreciate and like those designs. But after doing that, then I remove the tag of that company and replace it with my own tag. So my question here is there any likelihood of that company suing me for that action, for that using their material in order to change it or removing those tags and putting mine? That's my question. Thank you.
Okay, well, thank you. I mean, I think I would say you have to, or you are even supposed to pay for this. Legal advice is not like a knowledge sake question. It's more of an event that has happened or an event that is happening. So this kind of questions you're supposed to come to office and pay for consultation fee before we go ahead and answer the question. But in any event, um all these things I cannot give you a cut clear answer, but it depends on how you entered into the transaction with them, whether you have some agreements with them, right? If you don't have any agreement with them, it's just a common transaction that you did. You bought goods from someone. When I purchase stuff from you, when I purchase cloth from you, I am now the owner of the cloth, right? I can do what I want with the cloth. I can tear them apart, right? I can put them in dustbin. They are mine. I can do what I please with them. So they cannot take any action if it is just a normal, simple contract. But if you have an agreement with them, so I cannot say much on that until and unless I have the pleasure of reviewing the agreement to see the content, to see the terms and conditions therein before I can properly advise you on that. But if it is just a normal, simple contract that you purchase the goods without any terms, without any um, conditions, you can go ahead and do what you want with the cloth. So if you like, you can gift them out, you can give them to, you can gift the cloth to someone. If you like, you can sell them. If you like, you can dump them. If you like, you can burn them. They are yours, right? So you can do what you like with them.
Thank you so much. I'm much grateful. Thank you.
Thank you very much, sir. I'm
All right,
sure
thank
we
you.
all learned, and apart from the learning, one of us also received a free consultation from our facilitator. Thank you very much, sir.
Yeah, absolutely. i'm now i'm
So,
now
is
i'm
there
now putting it on you to make sure you collect my consultation fee from him. I'm putting it on you now.
no problem, sir?
All right.
Be rest assured. Okay, this is already 9:30. I guess no one has any question again. In order not to waste the time of our facilitator, I'm sure he has many things on his schedule, but he still availed himself to be with us today. Thank you very much, sir. We didn't take this for granted. We are very much appreciative. So, in view of this, I will call on Mr. Ibrahim Ahmad Tijani to give us a closing remark.
Hello, can you hear me?
Yes, we can hear you.
All right, thank you so much. Good evening, everyone. My name is Ibrahim Tijan Ahmad. I am the program coordinator of the Business Law Bootcamp. Because the meeting is already past the scheduled time and our facilitator is not also feeling so well, I would like to use this medium to properly express our heartfelt gratitude to the facilitator, Mr. Abdurrahman Nasir Salis. Thank you so much, sir, for such an insightful and engaging session. I'm particularly proud of the way you make it very comprehensive, making it um, a simplistic nature to all and sundry, regardless of one's level. We truly appreciate your time and expertise. As I said, our facilitator is not feeling so well today, but he insisted that the session hold. So lastly, before calling it a day, I would like to also appreciate all our participants here present. And also, I would like to give us a glad tidings that we have a lot of such learning activities at the Business Law Bootcamp. As such, I will urge all of us to be part of it. And in order not to take much of our time, I think I'm going to provide the contact details. So if you are interested in joining the activities of the Business Law Bootcamp, so you can contact us in any of the contact details that I'm going to provide in the chat box. So as I said, thank you all here for sparing the time to be here. And thank you so much, Mr. Abdurrahman Nasir Salis. We thank you and we pray that you have a quick recovery. Thank you so much, sir.
All right, thank you. It's also my pleasure and a privilege to be invited, to be given this opportunity. Thank you, thank you, thank you very much. Have a good day. Have a good night to all of you. Thank you. Good night.
Thank you, sir. So the final thing on our agenda is closing prayer, and I will call on Mr. Qasim Muhibuddin to give us a short closing prayer, and then we will quit. Mr. Qasim. All right. I guess we can just end it.